Be ready. 5 seconds to go. Start. The writ court cannot issue a direction which has the effect of conferring jurisdiction upon an authority which is not vested in it by law, nor can issue a direction so as to deny exercise of jurisdiction by an authority which is so vested in it by law. It is for the legislature to create forum, and once such forums have been constituted, the writ court would ordinarily not issue a direction permitting a different course. It appears that learned additional advocate general appearing for the state of Uttar Pradesh, being conscious of such statutory scheme, has taken the stand before us that a direction could have been issued by the writ court only to the registrar for holding election under section 25(2) of the act, and such a direction could not have been issued to the authorized controller for this purpose. It is otherwise interesting to note that in the present case, the authorized controller has further delegated its power and has directed the sub-divisional magistrate to conduct election, which is even otherwise not permissible in law. It is further apparent that competent authorities under the Act of 1860 have not yet resolved the issue of membership, nor the civil court has ruled on it, and therefore to permit the sub-divisional magistrate as delegate of the authorized controller to publish election program would amount to elections being rendered a farce. At this stage, I may also draw distinction between the authorized controller appointed under the Act of 1973 and the authorized controller appointed in respect of educational institutions recognized under the provisions of the UP Intermediate Education Act 1921. Section 16C of the Act of 1921 provides for framing of a scheme of administration to manage an institution. Section 16D provides that such schemes shall not be inconsistent with third schedule, which provide for procedure for constituting the Committee of Management as per scheme of administration by holding periodical elections. The Committee of Management of the institution is a distinct body. The scheme of administration also contains a provision that in case elections are not held within time, the authorized controller shall be appointed, who shall get the elections held to constitute the committee of management of the institution. There is a distinction between an educational institution recognized under the Act of 1921 as well as an educational institution affiliated to a university incorporated under the Act of 1973. In respect of the educational institution recognized under the Act of 1921, a specific power vests by virtue of a scheme of administration in the authorized controller to conduct elections, and that is why directions are issued by writ court to the authorized controller to hold election. The situation is different in respect of an educational institution affiliated to a university incorporated under the Act of 1973. The Act of 1973 does not provide for a separate scheme of administration, nor has any such scheme been placed on record conferring jurisdiction upon the authorized controller to hold elections of society for managing the educational institution. Dr. L.P. Misra submits that the said report was prepared without the participation of the petitioner company and without giving any opportunity to give a reply to the allegations that now form the basis of the passing of the impugned order. He further submits that the calculation as reflected in the impugned communication dated 25/7/2016, particularly in clause 9 thereof, about the act of the petitioner company being involved in overdrawing with a criminal intent of defalcation, was never intimated to the petitioner to explain the same, and even otherwise the entire calculation is erroneous. Hence, the conclusion drawn being patently incorrect, the action is arbitrary. Dr. Misra then urged that there was ample material on record to demonstrate that the entire delay had been caused on account of the unavailability of the environmental clearance that was the obligation of the State Highways Authority, and which admittedly took more than a year to communicate. The aforesaid delay in the execution of the project and otherwise all the hindrances were totally attributable to the respondent number 2 that have been completely ignored while passing the impugned order, and therefore the decision making process is clearly vitiated, being arbitrary and whimsical. He has further submitted that these facts about the breach on the part of the respondent number 2 were not even brought to the notice of the High Court, nor was the petitioner a party in public interest litigation number 15147 of 2015, where directions were issued for completion of the project wide judgment dated 21/4/2015.